Okay. I have called the cases. I've read the case numbers in the record. Pardon me. Sydney's still not back. Okay.
The people are ready and waiving opening statement.
Judges, as Sydney, the copies, I can't read this. These tickets you just sent me a half an hour, 10 minutes before trial. I can't read these.
They are light. It's a picture of a copy. They are light.
They are light, but I can read them. Just for example, on ticket ending in 753, any person who has custody of an animal shall prevent blah, 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 blah. I can read it, counsel. So I don't know what you're looking at that you can't read it. It is light, but I can read it.
I'm looking at the copy that was sent from the prosecution judge, and I'm pretty sure being that we're the defendant and these are criminal charges, I have a right to be able to review these tickets. I understand the
No, there's no question, sir. I have the same copy, and I'm just saying I can read it. So it's not totally illegible. It is light, but it is readable.
I can't make out my client's driver's license number. I can't make out the section number. I can barely make out the handwriting on any one of these citations. I mean, Sid, you have to agree that it's difficult to read. Like I can't see the section. I can't even see the section numbers on these tickets.
Well, I don't know if you're seeing something different than I'm seeing, because again, I agree it is light,
Judge,
but it is legible. Yes, sir.
This is what I see. This is what I see. I have 4 tickets I have 4 tickets.
I have the exact same thing, counsel. I have the exact same thing in front of me. 4 tickets on one page. It is light. I agree it is light, but I can read it.
Sydney, can you tell me V128751? I can't read the section in that.
652A.
I can see it on mine. It is light, but I can read it.
Judge, I understand, but the defendant is telling you that we can't read the photocopied citations.
Then we will come in and we will do this in court, and you can have a copy of it in court.
I want the originals. I don't want a copy. I want the originals.
I know what you want, sir. I can't give you what we don't have. You show me the law that says it has to be produced, then I will follow what you've asked for. But you have not done that. You don't seem to want to do that, sir. But I'm not dismissing it. So if you want to read this document where I'm saying it is legible, we will do this trial. We will do it in person, and you can sit there and read it and show me how you cannot read it. But I'm not going to keep going over this. I've told you I'm not dismissing it. So
I understand that, Judge. Give me 2 seconds. Let me see if I can decipher what was sent to me. Hang on. Judge, I'll proceed on what was sent to me. I guess the last thing I do is the court asked for a statute. The last thing I will argue is Michigan compiled laws 257-728, an arrest without a warrant for a misdemeanor citation. It indicates when a person is arrested without a warrant for a violation under this act or an ordinance substantially corresponding to the provision of this act and punishable as a misdemeanor under these conditions, the arresting officer shall, and I use the word shall, meaning that they must prepare.
I understand what shall means, counsel.
As soon as possible and completely as possible, an original and 3 copies of a written citation to appear in court containing the names and addresses of the persons, the violation charge, and the time and place, blah, blah, blah.
Let's back up a little bit. The arresting officer shall what?
Prepare as soon as possible and as complete as possible with an original and 3 copies of a written citation to appear in court containing the various name, charge, location, stuff like that. The officer shall inform the offender of the violation, which we're not contesting, and shall give a second copy of the citation to the alleged offender, which again, we're not contesting, Judge. What I'm saying is that this particular statute indicates there has to be an original produced and that the court doesn't have the original.
Ms. Rogers.
Yes. Could you, Mr. Hill, could you please repeat the language that it has to be produced to the court?
No, it doesn't say that. It says the person arrested. What I'm saying is that the original copy, I mean, it's common sense. The original copy is filed with the court.
Correct.
And
so
it was filed with the court. It
Correct.
was filed with the court.
How do we know that, Judge?
The court made a copy of it. So it was filed with the court because the court does not produce it now because that was filed with the court, but the court had produced a copy of what they took in. It was all photographed and they made a copy of it. It says it must be produced to the court, and it was.
Judge, the copy you have is from Ms. Rogers, yes or no? Ms. Rogers?
No.
Yeah,
no.
Yes. Yes,
that
it
is correct. Just for the record, that is correct. The copy that the court has that I gave to defense, I emailed to Madam Clerk sometime this morning. I got it from Investigator Green. This is a photocopy of his tickets that he has as part of his investigation. I believe the court rule does require that an original ticket be present at the arraignment. We are obviously very far past the arraignment. We're at trial stage here. That's how an ROA and a case number was created for these matters. The court rule does not say that the original ticket has to remain in the court the entire time. It just has to be there at arraignment. The defendant was arraigned. We're set for trial. The prosecution has given copies of the tickets to the court, and the people are asking to proceed.
Ms. Rogers, let me ask you a question. Were you there at the arraignment where the original ticket was provided?
I don't believe so. I'm not sure, honestly.
Okay, so we have no idea if there's an original ticket with a file, do we?
I don't do the entering at the beginning, so I don't know if the original ticket was there.
I'll rely on my previous argument, Judge. We're ready to proceed if it's denied.
Hold on one second. All right, counsel, from on a procedural matter, the tickets are submitted to the court. One of the clerks that does entry and case initiation based on the original ticket, they will enter it into the system. We can look and see, and we can see who the person is who had the ticket and initiated it, and indicate that they had this ticket personally in hand and it was presented to the court. Now, if Ms. Rogers wanted to go through that and she wanted to subpoena that witness and have that witness come forward and say that they had that ticket in hand, and based on their code that they entered into the system, they had the original ticket, they entered the case initiation, and that ticket was presented to the court. Because the court cannot find it now does not mean that there was any violation or lack in the process of how the ticket was initiated, original ticket that was entered into the system through case initiation. Now that's a long way to go, but certainly if Ms. Rogers wanted to do that, she could call a witness and say that person had that ticket in hand, did case initiation, and the court rules were followed and the ticket was entered into the system properly. Now, because the ticket is not available at this time, the original ticket or one is available of the four, but certainly they can put something on the record saying that ticket was presented to the court in a fashion that is required.
Judge, I understand what you're saying, but that's pure speculation. I don't think Ms. Rogers can.
No, I'm not saying that's speculation, counsel. We have an entry into the computer that someone entered it. Now, it would not be speculation if Ms. Rogers subpoenaed that person, have them come into court and say, I had this ticket in my hand and I entered into the system. That's what I'm saying. Okay. That's not speculation.
Sure. Is Ms. Rogers going to do that, or can I go forward with my motion?
I'm just saying she could.
Okay. I would like to subpoena that person. These are new arguments. We just became aware of not having the original tickets in the court file this morning. I did not have that person subpoenaed, and based on the arguments that defense have made this morning, I would like to subpoena that court employee and have them testify about what was entered in the system and what was present, based on the arguments defense is making.
I would object, Judge, because this is the third hearing that the city has been aware that the original tickets were not presented to the court. We're ready for trial today, Your Honor.
And we're all about justice, counsel, not ambush or something or something. So no, we're all about justice, counsel. We're all about justice. If that was not something that was argued before, because we weren't in court, and I don't know about this argument before. I've not heard that before, but certainly she could respond to something that she didn't know there was going to be an argument.
Can I finish my argument, Your Honor?
Yes.
This will be the third time that she's been here. I am doing this pro bono. My client works for the Detroit Police Department. She's taking time off work to be here. She's taken time off work 3 different occasions. It's not my burden, Judge. This is the prosecution's burden. They should have known this was deficient when they were at the last 2 pretrials. And I'm not dismissing it, counsel. I am not dismissing it. So it can be, Judge, it can be refiled. They can just refile it. I know they can do that. So, I mean, this is a complete waste of everyone's time, judicial resources, when it's the third hearing with no original tickets. They can turn around and refile it, and we'll address it then.
If defense's argument is for efficiency's sake of both the court and the defendant, to dismiss it today doesn't make sense because this process will start over again. And then the defendant will have to be arraigned and have pretrials and trial again. And it'll be a waste of the defendant's time and the court's time. The people are ready for trial today too. We have our investigator here. We have a civilian witness here that's been here for hours also. These are new arguments that have been made, and I want to address them fully. And I would like to have.
Let's do trial right now. I preserve my arguments. Let's go to trial. Let's do it now. I'm ready, Judge.
If we could do the trial in 2 parts then, because I still want to put that witness on based on the arguments that have been made earlier pre-trial.
Object, Judge. We're ready to go today.
These are big allegations that have been made.
Yeah, you know what, counsel, we can go today, but she can still ask for a witness and we can hold it in part. So just because we start today does not mean we have to finish today.
As long as the court knows I'm not waiving any of my previous arguments, just in terms
certainly
of
don't expect you to waive anything, counsel.
Thank you.
Okay, so I'm clear. We're going to go in 2 parts. We'll start today with the victim witness and the investigator and adjourn out for the clerk from the court to testify?
You can do that. You can hold it in part. And
Okay.
if in fact, nothing, yeah, okay. All right.
I guess it's my turn, right? Sydney, you waived opening.
Yes, I did.
Judge, usually I waive opening in this situation. I think I need to kind of tell you what really happened. This is a situation where on August 30th, 2020, my client was walking her dogs, a golden retriever and a mixed pit bull.
Counsel, let's back up 1 minute. You said what date?
Is it?
You said August something? That's not the offense date that I have.
I can't read the ticket, Judge, so I don't know.
I have offense date of September 15th, 2022.
I'm sorry to interrupt, just to address, we could bring the investigator out and ask if he could bring in a hard copy of these tickets. We aren't dealing with the photocopies, if that'll help defense. I can ask him or he's on the screen now. I can ask him if he can provide his actual copies, because I understand that these are a little light.
Can you just tell us the date that are issued in the citations?
The incident date happened on August 30th, 2022, and this ticket is issued on September 15th, 2022.
Okay, so August 30th, my client was walking down the street with a golden retriever and a mixed pit bull. A neighbor was walking towards with his dog. At that time, the neighbor's dog, not my client's dog, began lunging and barking at my client's dogs. She moved from the sidewalk to avoid any altercation between the three animals, because essentially the neighbor's dog was barking at. Well, let me ask you this: is there sequestration? You don't have your witness here, right?
The investigator is in the main room, but the witness is in the breakout room.
That's fine, thank you. As the neighbor's dogs were lunging towards my client's dogs, she addressed it by grabbing the dog harness to correct it and actually gain control of the animals. The neighbor's dogs continued to bark and lunge at my client's dogs, to which my client's shoe fell off. The animals became loose. They approached the neighbor's dogs, to which my client indicated they're friendly. Please don't be afraid. They're not going to hurt you in any form or fashion. To which the complaining witness began to kick, punch the animals that were being walked by my client. The animal, my client's mixed pit bull, did bite one of the other animals, but not before being attacked himself. So I want the court to be aware. You'll hear testimony from my client that although the dogs approached the neighbor's dogs, it was the neighbor's dog that actually bit my client's dog first. The moment my client told the dog to leave it, she's a dog trainer, she's a foster dog for decades. She'll explain that the moment she told the pit bull to leave it, he immediately left it and stopped. The neighbor is the one, Your Honor, that repeatedly kicked and punched the dogs at that time while the dogs were actually sitting and behaving. My client asked the neighbor to stop, to be calm multiple times. He actually made contact with my client, the neighbor, and the dogs. And at one point, he tried to actually kick, I believe, one of the dogs, the golden retriever or the pit bull, missed and actually kicked my client. At that particular time, because there was a melee going on, once the neighbor had actually made contact with my client, the golden retriever doesn't know that the neighbor was trying to kick another dog. You'll hear testimony that the dog did bite the neighbor, but it's not because the dog was unleashed or out of control. It was because his owner just got assaulted. So that's really all I want to say in terms of factually, Judge. You're going to hear that from my client. This is a situation where I think that, and Judge, you'll hear testimony that these charges or these allegations weren't presented to the police till 10 days after the fact. And the reason why they were presented 10 days after the fact is because the neighbor was so, in my opinion, out of control, sending letters to my client, dropping off letters to her house, demanding that dogs be euthanized. And at that point, I think when my client said that it wasn't their fault, at that point, that's when he decided that he was going to go to the police. I told my client in retrospect that I think she should have filed her own police report for being assaulted by the neighbor. But at the end of the day, she doesn't want to create chaos. She doesn't want to add to what's already a chaotic situation. And she didn't. I think she should have, but she didn't. I think the charges should have been initiated against the actual neighbor and for failing to control their animals. But I don't think the investigator ever asked my client's side of the story. I think from what she told me, she got tacked on the door a couple tickets. So all you have is he said, she said, and I think, you'll see my client's credible, and she'll go into the actual nature of the injuries and stuff like that once we get into testimony. Thank you, Your Honor.
Thank you. Ms. Rogers?
Yes, thank you. The people call Mr. Daniel Kincaid.
Okay. You didn't want to make a opening statement at all?
I already waived opening.
Okay, all right. All right. Let's see, where's my witness here? Investigator Green, wait a minute, who did you want to call, counsel?
Mr. Kincaid. He should be
I
in a
don't see
breakout
him.
room.
I don't see, oh, is he in a breakout room? Okay. Hopefully the system will work today. Some days it lets me bring people out of the breakout room, and some days it doesn't. Yeah, there.
Thank you, Judge. Good morning, Mr. Kincaid.
Good morning.
Let me swear the witness.
Oh, thank you.
Okay. All right, you don't have your name on the screen, so yeah, it should be. All right, Mr. Kincaid.
Yes.
Is that D-A-N-I-E-L, last name K-I-N-K-E-A-D?
Correct.
All right, would you raise your right hand, sir? State your full name.
Daniel Hunter Kincaid.
Swear or affirm to tell the complete truth?
Yes.
You may lower your hand. Your witness, counsel.
Thank you. Good morning, Mr. Kincaid. Thank you for appearing today.
Thank you.
I'm gonna ask you some questions about what happened on August 3rd, 2022.
30th. Sorry.
Oh, I'm sorry, August 30th, 2022. So on the day in question, what were you doing?
That evening I was walking our dog. I left our home, which is just north of Bloomfield, on Briarcliff. I was walking southbound on Briarcliff on the east side of the street. Yeah, I can leave it there.
Okay. And you said you were walking your dog, correct?
Yes. Yes.
And what kind of dog do you have?
It's a Beagle mix, Chelsea.
Okay. Is Chelsea your dog's name?
Yes.
Okay. And how big is Chelsea?
I'd say, I don't know, medium size. I don't think we've ever really weighed her, probably 30, 35 pounds, something like that.
Okay. And you only have the one dog, Chelsea, correct?
Correct.
Okay. And how long were you walking Chelsea before anything happened?
Maybe just a couple of minutes. We had walked down and had crossed the street and we're heading down further down Briarcliff, and we were probably maybe 2 or 3 doors down, walking southbound again. And that's when I saw her walking on the other sidewalk with what I believe were two large dogs. And
Okay.
yeah, I can leave it there. Sorry.
And when you're walking, was your dog Chelsea on a leash?
Yes.
And you said you were walking on Briarcliff, correct?
Correct.
Is that in the city of Detroit?
Correct. Yes.
Okay. And then when you're walking on Briarcliff, what happened? Did dogs approach you? Did a person approach you?
Both. So as we were walking, I saw her come northbound on the west side of the street, and she was on that side, and she started coming across the street with her 2 dogs. And as they were coming, they were kind of angling a bit toward us, but often in our neighborhood, when people cross with other pets, they'll cut the angle, behind you. and I thought that's what she was doing. But, you know, it's one of these things, like literally within, I don't know, 3, 4, 5 seconds, I could tell that they were actually starting to come a little bit closer. And a lot of dogs will do that and sniff, and I wasn't thinking much about it, but really literally in that moment, like from seeing her in the middle of the street coming across, and I could tell she was being pulled, from that, it was like instant boom. It was just, you know, it kind of just blows your mind. They were on top of us. They came and got I believe the pit bull was right on Chelsea from behind right away, and the other dog was kind of coming around the other side. It's a mess, and I can hear my dog just scream a scream I never want to hear ever again.
So
And
you said one dog was a pit bull, the other dog was what?
I think a golden retriever, something like that.
Okay.
All right, thank you.
And then I'll just close out that state. So they're on the pit bull is on her, and I it just happened so fast. I'm trying to get her, and then I just kind of like picked her up, really just trying to get her out of it and heave back. And now I'm on the walkway up to the home, whichever home.
Sir, I'm going to ask you to not use pronouns he or, you know.
Oh, I'm sorry. The name, yeah.
A name.
Chelsea, the dog. Sorry, I have Chelsea. So I see that the other person's dog was attacking my dog in a matter of seconds, and as I heard that sound and saw it, I went to pick up my dog Chelsea, and I could tell the other dog was hanging on, and so I heaved as hard as I could back, and ended up kind of then falling down on my back. My dog is there. The pit bull is going to town on her back end, and then the golden retriever is coming around, and it was a kind of a melee, and then the golden retriever was on my left hand as I'm trying to brace to get our dog, and I could see Miss McAdow behind and in that scene, and she had a look of terror on her face and was stepping in to try to deal with one of her dogs at that moment.
Okay, thank you. To back you up a little bit, when you said you were walking your dog Chelsea, and then the defendant is walking the other direction, are you guys all walking on sidewalks?
Yes, initially. So I'm on the sidewalk headed southbound on the east side of Briarcliff. She was walking northbound on the west side of Briarcliff. But like I said, that within a couple homes there, she started to cross the street and looked like she was going to angle past us, which again, we typically see there, right? People walk around you just to get to the other side. But in a matter of, 3, 4 seconds, it turned sharp, and I could tell she was getting pulled across. And at first I thought they were just going to like check our dog out. But that it just, literally in a split second.
Okay.
Yeah,
So from what you could see, so the defendant's dogs were on a leash, correct?
correct.
Okay. And they were pulling her though? Is that why
Correct.
it appeared she crossed the street?
Well, at the time I didn't know. I mean, dogs are, they're always there's tension in the line. So I thought she was just walking them and walking behind us. But then, again, this is split second stuff, like 1 or 2 seconds. I could tell it right in that moment, like, well, they're really coming closer. And I thought, well, maybe they're curious. But then the movement was very fast, and in a split second.
Okay.
Yeah.
And when that happened, did your dog bite the defendant's dog at all?
No,
Okay.
her dog was attacking my dog from behind. My dog's face was never around. I mean, yeah.
Okay. Were both of the defendant's dogs attacking your dog?
In that moment, all I could see right then was the pit bull attacking my dog. That's when I heave back, and when I heave back, and I'm on my back, and I think the other dog, it must have been the golden retriever, was on my left hand. As I'm trying to grab my dog, it's it's a mess.
Right.
Yeah.
When you said on your left hand, meaning on that side or biting your hand?
Biting my left hand. So I'm trying to work, pull, on my dog and I'm and all this, and then something's coming around and getting my left hand, which I can see like the dog there, and I don't know, it's hard to, it's just a melee of,
Right. So did the golden retriever bit you? Is that correct?
yes,
Okay. And then the pit bull bit your dog, Chelsea?
correct.
Okay. And then your dog, Chelsea, was bit from behind on the butt?
In multiple locations, I believe on her left rear leg and her upper thigh, underneath in her groin, and a bit, like all around her groin, honestly. It was
Okay.
all in that area.
Okay. And were you bit anywhere beside your hand?
No.
After this happened, it sounded like it happened very quickly. What happened from there?
I believe there was a moment where Miss McAdow somehow, I think, got her pit bull off. I'm not exactly sure what happened. I think she told me later that she had pulled the dog's mouth and somehow got in there, which is amazing. Pulled the dog off, and it, I'm trying to like get my bearings. My dog is howling. There's literally blood everywhere. And all I can think of is to get up and try to protect my dog. And I could tell it was not good. And as I looked to our house to figure out if we can get there quickly, I told her, I said, she was apologizing repeatedly. I'm so sorry. I'm so sorry. Like, and I said, just don't leave. Don't go anywhere, please. It's coming back to me now. Anyway, so I tried to get my dog down there to get her home, and then got a piece of paper. My home is like four houses northbound on the street. Get to come back to her to jot some stuff down, and then and I barely remember the details there because all I wanted to do was get her information and go, because I knew we had to take the dog to emergency somehow because there was just blood everywhere, and I didn't know what was going on, but I thought that it was bad. So
Okay. Yes. Thank you. So when you went back to the house to get the paper, was the defendant still at the location?
yeah, she was still at the home where this happened. She was still there.
Okay.
Yep.
And did she give you the information that you're
Judge,
looking for?
Judge, I'm gonna object to relevancy. Why are we talking about exchanging of information when we're talking about dog not on a leash and whatever the other charges are? I don't see how this is relevant whatsoever.
Ms. Rogers?
I can move on. That's fine. When you came back to the scene, were the dogs still with the defendant or back at her house?
I don't recall. I believe they were. I have to imagine they were still there because I was very fast coming back, but I don't remember just beyond talking to her.
Okay. And so you had no interactions with the dogs the second
Correct.
time around.
That's right.
And going back to the original incident, the bite incident, did the defendant let go of the leash when the dogs were biting?
I don't know. I would imagine so based on what was going on, because I think then she was trying to get in, to work in that, to help. But I don't know. I would have to imagine her hands were off the leash at that point, trying to do whatever. At that point, the leash wouldn't have mattered. It was, crazy.
Okay. And when you went back to your house, did the dogs try to follow you back?
Judge, I'm gonna object to this line of questioning. I don't understand that relevancy. From what I can read on, I think the two citations which would be applicable. Again, I can't read the section numbers, but any person who has custody of an animal shall prevent the animal from engaging in nuisances and failing to provide a leash. That would be the only two I think this testimony is relevant to, and I have no idea why the dog's following him back, which they didn't, but I'm not really sure where this is going.
We don't know the answer to the question if they did or not, but it goes to if they're off leash. If they're following him back, they're not on the leash then. It's directly related to the charges.
I apologize, Ms. Rogers.
That's okay. Thank you. Mr. Kincaid, if you could please answer the question.
And that was whether or not the dogs were following me back to my home when,
That-
no, I don't believe, I never look back to, but if they were, they would probably would have been coming after. I don't recall them coming after me.
Okay, thank you. Were you able, that day you said that your dog was bleeding and had a lot of injuries. Did you have to take your dog to the vet?
Yes, we took her to an emergency vet that immediately that night.
And what treatment did your dog have to receive?
She received a repair on a number of the wounds that she took from the attack. And it had pulled apart a lot of different tissue and stuff, so it took overnight to do. So there were, I don't know there are drainage tubes everywhere. It's stitches it was just, I don't even know how to describe it. It was just a mess down there. It was just a mess.
Okay, thank you. And has your dog fully recovered now?
Yeah, I think physically she's fine. The scars are still there for sure. I think physically she's doing well. I will tell you though, since then it's just, we have to really be careful because she gets really skittish. She is very afraid outside, and I'm trying to, make her feel okay. But we just take it one day at a time.
And did you have to receive treatment for the injuries to your hand?
Yes. Yeah. So that night I went to, sorry, or I can.
No,
Okay.
Go ahead. What treatment did you receive?
So I'll just say that evening I went to the emergency room at Beaumont in Royal Oak. There was a long line there. I left, and they had told me to bandage up the cuts and everything, and to hold it together, and I could get to a Beaumont outpatient kind of thing in the morning, which I did. And there they cleaned the wound. They went through all the puncture wounds that were on my basically my left hand, the left side of my left hand. They cleaned those all out, and then did a kind of tape suture on that side of my hand, and that was it. Overall, still to this day, that part of my hand obviously feels a little funky, like it's asleep, but I've recovered fine.
Thank you. Do you know if you had to receive additional treatments for rabies?
Judge, I'm gonna object to relevancy.
There's a charge for unvaccinated dog, which would be a rabies vaccine.
Isn't that something that the inspector is going to testify to?
But if Mr. Kincaid had any additional treatment and injuries due to the dog being unvaccinated.
But he was,
It's
okay.
relevant, counsel. Well,
I don't. Sorry, I don't believe I did get anything relative to that.
And did the defendant ever show you any proof of the dog being vaccinated?
No.
And if you could please identify if the person is on the screen, the person that was with the dogs that bit you and your dog on August 30th, 2022, if you can identify that person if they're on the screen, and please identify an article of clothing that that person has on.
Sure. Sorry, it's a little small. I see Michelle McAdow. She's in the upper right part of my screen. I believe it's a kind of green, darker green shirt, red hair.
Thank you. May the record reflect the defendant's been identified.
record so reflect.
And did you have any interactions with the defendant past August 30th, 2022?
Yes.
Judge, sorry, I'm going to object to this line of questioning for relevancy. Anything that's post, all I see is an unleashed dog, and any person, again, I can't read it, but it has no relevance to the actual charges unless.
I don't know what the question is, counsel. If in fact the question, if it is not relevant, I'll strike it, but I don't know what it is, so I can't say it's not relevant at this point. But I'll hear it if it's not relevant, or if it's cumulative in some fashion, then I'll strike it.
Thank you, Judge. Briefly, the question is in response to, or because of defense's opening saying that there was issues post this, that the that the victim was constantly contacting the defendant, and what was going on between the two of them.
I think you made that part of the argument, counsel. Go ahead.
Judge, it's not, Judge,
Yes.
it's not testimony. My opening statement is not testimony.
I know it's not testimony, counsel, but you raised an issue on the record. And if she wants to counter that, then she can do that, because I don't know what your argument is going to be now after that, after you made an opening statement saying what was going to happen. It's relevant. Go ahead.
That's not
Yes.
testimony. What the proper
It doesn't
procedure-
matter, counsel.
Judge,
It's your opening
Judge,
argument. Your
Judge.
opening argument is a roadmap as to what you think the evidence is going to show. And if that roadmap goes askew, she gets to counter it. She gets to say something, because she doesn't know what you're going to say in your. Go ahead, counsel.
Judge,
You
Judge,
made
I have to put this on the record. I'm sorry. Okay, procedurally, this is done improper. This is completely improper. The proper procedure is to call him as a rebuttal witness if once testimony's on the record establishing there's a post discussion.
Also, did you say what the evidence was going to show?
Yes, and Judge, you have to wait for the evidence to
So
show.
how do I know
first.
what your argument is going to show when you close? So you said it, counsel. She gets to address it.
She does not get to address it because it's not testimony. If my client.
No, you get to address it because you said what you're going to show. If you tell the court what you're going to show or what the evidence is going to show, she can say whatever attorney said is going to show, let me show you why it doesn't do that. Yes, counsel, if you make an opening argument saying what the evidence is going to show, she gets to counter that to show that evidence did not show that. You did that, counsel. So
There's no evidence,
your
Judge.
objection
And that's
is
the
not.
reason why a jury instruction says that the attorney's opening arguments and closing arguments are not testimony. There has to
It's
be.
not testimony, and it's not, no, it says it's not evidence. It says it's not evidence. But if you have told the jury what they're going to see, she can say, this did not happen. So yes, you can do that, sir. So move on. Go ahead, Ms. Rogers.
Thank you, Judge. Mr. Kincaid, did you have any interactions with the defendant after August 30th, 2022?
Yes.
And what were those interactions?
We reached out to her just to talk about what had happened and to make sure we could get vaccination records from her and just talk it through. And I can't remember the exact date that we met with her initially, but she did come. I think we'd reached out as she shared her information. At one point we met in our driveway. My wife and I were there speaking with her. I believe, I can't recall if it was prior to that or immediately following that is when I think I sent her a letter before that on September 3rd and put it in her mailbox, and I outlined, what had happened and how our family was impacted by it, but also in there had cited things where we wanted to make sure that given how this happened, this unprovoked, really kind of vicious attack happened, that no one else.
Objection, Judge. I'm going to ask the court to strike
Sure.
this line of questioning. This statement. Again, there's
Understood.
no evidence whatsoever.
And so I've already ruled. When you said what the evidence is going to show, she gets to show that the evidence that did not happen, or it did happen, or whatever. But yes, because that, counsel, that's like saying you got a jury in front of you and you're saying your opening statement, you're going to see that my client never had a gun. And then you say when the other party says, did you have a gun? You say that's not relevant. There's no, I didn't say, no, if you state what the evidence is going to show, she can rebut that. Go ahead.
Yeah, so to clarify, I had created a letter. I think I put that in her mailbox. I think she came down either later that day or the next day. We spoke about the letter. The letter is dated September 3rd. And in there, we basically, the key part of it was that we wanted to make sure that we could have the vaccination records to understand just that, to know that the dogs were vaccinated. And we also asked that, recognizing that we understood she took in other animals that she's doing a rescue, that she think about that carefully and that we make sure that nothing like this can happen again, in our neighborhood. And that meant that those dogs either had to be quarantined, like held back safely, and so like no one else could get hurt, or
Sir,
Yeah.
sir, hold on one second. Now, Ms. Rogers, I think we're going a little far now.
Okay.
Because now we're not talking about the dogs at hand. There's discussion about other dogs they may be taking in. So let's narrow the focus to the dogs that were involved in this.
Yes, thank you, Judge. So you did have interactions with the defendant post this incident, correct?
Correct.
Okay. And you were asking for her documents and
Yeah.
about, okay. And this
Yep.
is a neighbor of yours, correct?
Yes, down the street, yes,
Okay. So you do have future concerns because you guys are neighbors.
correct.
You sent her the letter and then you talked in person a few days later. Is that correct?
I believe so, yeah.
And did you ever contact the defendant post that, besides a letter and talking in person in the driveway?
We did, we provided it, we spoke with her at our driveway, talked about, I don't know what I can say on this thing anymore, the medical bills and just making sure her dog, that this didn't happen again. We hadn't heard back after that at all. We hadn't received any information to validate that the vaccinations. And so we sent her another letter, and that was on September 11th. And I cited in there just specifically what we were looking to get the full vaccination documents of both of her dogs. Yeah.
Okay, thank you. So when you sent the second letter, any interaction past that?
No.
And did you talk to anyone from animal control regarding this incident?
Yes, there was a police officer or inspector that came and spoke with us about what happened.
Okay. And did he come and speak to you because you called, or how was he aware of this incident?
We had I think we had notified the 12th precinct. I'm trying to remember now. I think we had notified the 12th precinct that this had happened. And I think that's subsequent to that, I think they had the officer come and talk with us.
I see. Okay. So then once you called, someone came to your house.
Correct.
And do you recall how far after the incident someone from Detroit Animal Control came to your house?
I honestly, I don't know. It was probably I think within, if not a week, then just a little over that.
Okay, thank you.
Yeah.
Nothing further from the people.
Judge, I just realized
Counsel,
something. You didn't swear the witness in. Just give you a heads up.
sure I did.
I
started out before I let Ms. Rogers speak, didn't I?
okay.
I thought I did. I could have sworn I did. Well, let me do that then. I thought I did that. First thing I did. Mr.
Okay.
McKay, yeah. Sir, I could have sworn I did this, but counsel says, and I trust that. Raise your right hand, sir. State your full name.
Daniel Hunter Kincaid.
All the testimony that you previously provided and any additional statements or questions that you answer, do you swear that those are the statements that you have made are truthful and the statements that you will make are going to be truthful?
Yes, I do.
You may lower your hand, sir. Thank you.
Sydney, before we get started, can you, from the left to right, the tickets, can you give me the section numbers? I have the middle one, the 5-1. I can't read the first two and the last one.
Ticket ending in 8753, section number is 613A.
Yep.
Ticket ending in 8400, section is 651A.
Okay.
Ticket ending in 8751 is section 652A. And then the last one is 622B.
Thank you. Mr. Kincaid, my name is Ryan Hill. I'm an attorney. I represent the defendant. I'm going to ask you a series of questions. I want you to pause and wait. Ms. Rogers may have an objection. And if you don't understand the question, just say, Ryan, repeat it, okay? And I'll ask it again, okay?
Okay. Yep.
In terms of trial prep today, did you speak to anybody besides Ms. Rogers? I don't want to know the context, but I want to know if you spoke to anybody of what you're going to testify here today about.
No.
Okay. Would you agree with me that those letters that you put in my client's mailbox, they also had a demand to euthanize the animals? Yes or no?
No.
You didn't make a demand to euthanize either one of the dogs?
No, I'd like to clarify.
No, I need a yes or no answer.
We did not demand. We asked that she share her vaccination records and ensure that she can keep her dogs safe so they can't hurt anybody. If she cannot, then we felt like that's the only other option given everything that happened.
So in those letters, you did make a demand for them to be euthanized if she was unable to provide vaccination, correct?
Good clarification. Yes.
Okay, all right. And she provided you proof of vaccination, didn't she?
No.
She never did?
No.
Do you remember making an oral statement to her on the date of this incident where you demanded her to euthanize her dogs? Yes or no?
No.
Were you aware that you were being video recorded after the incident? Yes or no?
No.
Okay. Let me ask you again, Mr.
So,
Kincaid.
counsel, let me say this. I do not believe that the lawyer can ask a question and tell them how to answer at all. I do not allow lawyers to tell someone yes or no, because the answer is often not a yes or no answer, even though that's all you want. So I do not require witnesses to respond yes or no. You can ask a question, you can't tell them how to answer in this courtroom. So,
Judge, I'm so sorry. But when I ask a question that requires a yes or no answer, that's what I'm going to say. If it requires an explanation, Ms. Rogers.
counsel, I don't care what answer you want. The person has a right to answer as long as they're truthful.
I can't fathom this. I can't fathom when I ask a question on whether or not yes or no, did you
counsel, I do this in every trial. I allow the attorneys to ask the question, and I don't tell them, they can't tell a person how to answer. I don't care if you only want a yes or no answer. The answer may not be a yes or no answer. So the person has to answer the question as long as it is responsive to your question, but you can't tell them how to answer in this courtroom. So, and I don't think that is fair to any witness. Say, I want you to answer it the way I want you to answer it. No, you can ask the question the way you want it. You can't tell them how to answer because the answer may not be complete. Just because you don't want a complete answer, you don't get to tell them how to answer. That's the rule in this courtroom. In every case, I don't let anyone tell a person, ask the question and tell me, I want to tell you how to answer it. So you can continue.
I mean, Judge, you just handcuffed me. I can't proceed.
No, I didn't. I didn't.
Judge,
I didn't. You can answer your question, sir. What you're doing is
you essentially told me that I can't practice law like I've been practicing law for the last 18 years.
I don't care how you've been practicing counsel.
I cannot defend my client restrictions. I'm sorry. I cannot.
What you're saying is, I want to handcuff, sir, I'm talking now. What you're saying is, I don't want you to handcuff me, but I want to handcuff the witness. I want to ask them a question and I want to tell them how to answer. No, all I want is a truthful answer. You don't have to tell, they don't have to tell them. It's a truthful answer, sir. It doesn't have to be the way you want it, as long as the answer answers your question, not necessarily how you answer, how you want it. So that's the way we're going to proceed with this. I don't want a yes or no answer. I want a answer that a question the witness can answer the way he wants to answer, as long as it responds to your question.
I do have a procedural question. Has Ms. McAdoo done a written waiver of jury? Does the court know?
I don't know. You're her lawyer.
Judge,
did you request it?
No, I didn't. I want to know if there's a written waiver of a jury trial in the court's file. Ms. Rogers, are you aware of a written waiver?
Attorney, sir, did you submit a waiver of trial, of jury trial? Did you?
No, I did not. But
then how would it be? How would it be in the court file, sir?
There's two other hearings. I just didn't know. Thank you, Judge. I'll keep on going. Mr. Kincaid, you heard the judge's directions, I guess. So if you want to elaborate, I'm going to ask.
It may be a yes or no answer. I don't know, but you don't get to tell them how to answer. That's all I'm saying.
I wasn't telling him how to answer, Judge. I didn't.
Yes, you did. Yes. You said yes or no. That is a direction from you to tell them how to answer. That's exactly what it is.
Because that's what I'm asking for, a yes or no.
That's what you want, counsel, but that may not be.
I'm on cross. I can ask my questions.
But you can't tell them how to answer. Answer any question you want. You can't tell them. I'm going to give you a question. I want to tell you how to answer. That's what I don't allow. You can ask the question. If the answer goes off If he's trying to say something that is not a direct answer to your question, we'll strike it.
Judge, Ms. Rogers has the opportunity to follow up.
No, sir, I am telling you how I conduct my court. Ask the question, do not tell them how to answer. If the answer is not responsive, we'll strike it.
I can't proceed then. I can't. If the court's going to restrict me on how I have to answer my questions, I can't proceed.
I'm not restricting you on any question,
You are,
counsel.
Judge. You are, Judge.
No.
I can't proceed, Judge.
Well, then don't proceed, counsel. But I'm telling you, you can ask any question you want. Just because they answer it in a way that you don't like does not mean you are not able to ask questions.
I'm at an impasse. I don't know what to do.
I don't know what you're going to do either, then, counsel, because I can't tell you how to practice law. I can only tell you how what you can't tell a witness to do. That's the only thing I'm saying. You can't tell a witness what to do or how to answer.
And I've been doing it wrong for 18 years, Judge.
No, you're doing it the way other courts allow you to do it. I don't allow any lawyer to ask a question and then tell them how to answer. That doesn't make sense to me. That's not the answer I want to give.
I give
As
them two
long as
options.
it's responsive. As long as it's responsive, sir.
I give them two options, Judge. I'm not telling them how to answer anything.
Then what is that, counsel? I want a yes or no. You have told them how to answer. The answer may not be that clean cut or clear. The answer may come out yes or no, but you don't tell them in advance how you want them to answer.
Can I talk to my client in a breaker room, Judge?
Yes, you can.
Actually,
Were
Ms.
you
Rogers,
in
Ms.
a,
Rogers, will you come in with me too, please?
Yes, if you'd like me.
okay, Mr. Mac, I'm sorry, Miss McAdoo. You were in a breakout room with Attorney Rogers earlier. If you touch your screen, you should see 3 dots and you should see something that comes up that says, join the breakout room. You can go back into that breakout room. If you can't figure it out, I can move you to a different breakout room, but I can't send you back into that same breakout room because your device is already saying you could go back in. She's gone back in. Oh, she hasn't yet. Ryan Hill has gone in. Do you see it, Ms. McAdoo?
No, Your Honor, I do not. I was not in a breakout room with.
I show that they had you in their scheduled one. I'm just going to move you. I'm going to move you both to a different breakout room.
Thank you.
All right, attorney. Okay, let's see.
And Judge, I'm assigned to breakout room 3, which I don't think Mr. Hill is.
Okay, I can move you to 5. Awesome. Mr. Walker.
getting here, man. Can you turn the alarm off?
I certainly can do it right now.
Okay, all right, we're going in.
All right, hold on, give me 2 seconds.
Okay.
Okay, Andre,
Yeah,
it's disarmed.
okay, we're going in and we'll get you, I'll call you back, okay?
All right, appreciate it.
All right, bye-bye.
Bye. Attorney Hill,
Yes, Judge.
Ms. Rogers. Okay, I think we don't have audio for Attorney Rogers now. Let's see. Oh, she muted. Okay. Attorney Rogers,
Yes, I'm here.
Attorney Hill, there's something I want to bring up to both of you, and you can discuss how you want to proceed on this matter. But I see what it looks like might be potentially errors on 2 of these tickets, or something that on the ticket number D128753. Although I have a light copy, it does not look like there's a officer's name on it or a signature. On ticket number 128751, although it is light, it is a different date for the incident.
Motion to dismiss.
This did happen at a different date, as I think the investigation was continuing on. We can piece this one out and do it as a separate trial, or we can combine them.
Okay, I would have thought that these were the same date because the ticket numbers are consecutive. I have 1288751 and 128752. One date says September, looks like 11th. So I would find that that would be the September date on a ticket number that was earlier, and then the August date on the ticket that would have been consecutively, which matches the earlier tickets.
That is correct. If I could, on direct, ask Investigator Green on how these dates and tickets were issued.
Is that something you want to do in a breakout room with the investigator? Because to me, I can't fathom how the ticket numbers would have been out of order in that fashion. So
Yes, I can ask him in a breakout room.
as far as the ticket that is has no investigator on it and no signature, are you dismissing that one, or Attorney Hill has requested a dismissal on that?
Is that 5-3? Is that 5-3?
5-3, correct.
Okay. And
If I could talk to investigator Green in a breakout room.
Very well. Investigator Green, let's see, where are you? Investigator Green?
Yes,
Unmute
Your
your
Honor.
microphone.
Yes.
Can you touch your screen and go back into breakout room? You were in breakout room earlier, breakout room 2.
Yes, sir.
And Ms. Rogers, I'll put you into.
Sydney, I made you a co-host so you can.
Yeah.
I'm ready whenever the court is.
want him. Is he talking right now?
I have no idea. You know, these-
You're absolutely correct. I apologize, Attorney Hill. I was just talking away and I was muted, didn't realize it. I was asking Attorney Rogers how one on ticket number V128753, which appears to be a ticket to me that has no officer's signature on it or any type of. I did raise that to the to both attorneys, and Attorney Hill has asked for a dismissal on that matter.
Yes, thank you for bringing that to my attention. I have spoke to Officer Green. The people are not proceeding on ticket ending in 8753, but are proceeding on ticket ending 8751.
Okay, I'm certainly like to understand how that ticket has a different date of incident. Certainly follow-on tickets we can do that, but that ticket has a earlier number than the second ticket. It's 12 days earlier than the ticket ending in 752.
Ray, I understand.
No, I apologize. I said that backward. The ticket number is 11 days after, but it has a earlier ticket number. So I guess someone can skip a ticket and then come back and write another ticket later, but it's 7 days, it's 12 days later. That just seems a little bit odd to me.
Correct. I'll put testimony on in direct, but what happened here, animal control writes and investigates differently than Detroit Police Department does. And if you look, all of these tickets are issued on the same day of September 15th, 2022. But the top date is the incident date of when the behavior happened. So on ticket ending in 8751, the investigator Green attempted to give the defendant additional time to get in compliance. She did not, and that's why there's a later date on it, but it's earlier in the sequence of ticket numbers.
I imagine that'd be quite the subject of cross-examination, but certainly you have an explanation for it, and we'll proceed. And obviously, counsel can cross on that. So,
Okay, sorry, just for clarity, because I can't read the ticket. The one ending in 53. What is
that's
that?
the one that one's dismissed. That is a ticket that is any person who has custody of an animal shall prevent the animal from engaging in nuisance, menacing, potentially dangerous behavior.
Okay, and the 5-1, the one that the court may have had an issue with. What I can't read that. What is that one alleging?
Ticket is fail to vaccinate or provide proof of vaccination.
Okay.
And I'm actually reading this from the copy of the ticket. So
okay,
the photocopy of the original ticket. So
okay. I guess, Judge, I'm going to proceed with cross.
Very well. Thank you.
Mr. Kincaid, so you heard what the judge said. I may, because of habit, say yes or no. The judge has indicated that you don't have to answer yes or no. You can elaborate. So just what if I do say that and you want to elaborate, I guess you're allowed to, okay?
Okay. As long as it is responsive to the question. It can't go off on a tangent or talk about other things.
Sure.
As long as it's responding to his question.
Your dog Chelsea is a Bugles or a Beagle?
Beagle mix, yeah.
Okay. And let me ask you this. How long have you had her?
We got her in 2019.
Okay. And have you had any behavioral issues with that with Chelsea at all? Any viciousness, anything like that?
No.
Has she ever bitten another neighbor's dog two or three doors down from where you live?
No.
No. She ever attacked another dog?
No.
Now, your prior testimony, you indicated that my client's dogs were pulling. Isn't it also true that Chelsea, she saw the dogs, correct? And she was also kind of pulling you in that direction. Is that accurate?
I don't, it may be, I mean, I know she turned to them and was probably, leaning forward, but not, she wants to check them out there. That may have happened. Yeah.
She was barking. She was barking as well, right? Barking at the dogs.
I don't know. I really don't know.
Okay, so you don't know if she was pulling, you don't know if she was barking, right?
Yeah, right, yeah.
And you said something interesting. You said I was trying to pull my dog away during the altercation and all of this. Do you remember making that statement?
Yeah, I don't know exact wording, but yeah.
What do you mean by all of this? You were doing additional things to diffuse the situation, weren't you?
Well, when you mean like, so what happened when the dogs came across, I saw them, I thought they're going to pass by. As I mentioned, the split second, they were on us. Pitbull had gotten my dog, and that's when I realized, and this is happening literally split second, that this was happening. And I tried to get her out of there, but the dog was pulling on her, and all I could think of in the moment was to pull as hard as I could to free her.
Let me stop you there. You said in the moment you were trying to get her out of there. Isn't it also true? You were upset, right? You were screaming and yelling at my client to get the dogs off, correct?
Yeah. When I was on my,
That's fine. I don't.
Yeah.
Okay. You were also punching and kicking the two dogs that were on the ground, my client's dogs, correct?
No.
You never made contact with any of the dogs?
Well, yeah, them on, her one dog on my left hand and the other dog on my, no, I was not punching or kicking a dog. Look, man, I'm on
all I ask, I don't need an explanation.
Okay.
Ms. Rogers she has an opportunity to do that. Now, let me ask you this. I'm going to say yes or no, but if you want to, explain, I guess the court will allow you to. Isn't it true that when the dogs actually met, that your dog, Chelsea, bit the pit bull first?
No.
Okay.
No.
Okay. Isn't it also true that once my client gave a command of leave it, the pit bull stopped immediately and sat down? Is that true?
No. And
okay. And did you ever actually attempt to kick one of the animals, miss the dog, and actually kick Miss McAdow?
No.
You never made any contact whatsoever with her?
No, I don't think so. Look, I'm on the ground. This is insane, right? Everything that's happening around me. I may have touched her, hit someone with my foot. It was crazy. I don't know how else to say this to you guys. Like,
I understand that, but let me ask you this. Isn't it true that after you might have touched her with your foot, which I would call a kick, after you might have touched her with her foot, isn't that when the golden retriever bit you? Yes or no?
No.
That happened before?
What happened was her dog got to my dog. I realized what was going on. I heard the scream. My instinct was to pick my dog up and just pull her out of that. When I did,
I heard that testimony before. I want to ask about the time when
counsel, don't cut the witness off. He may have more to add.
He's not responsive, Judge. I asked a question about
I don't know if it's responsive because you stopped him.
Judge, you have to let me cross.
No,
you have to let me cross, Judge.
No, hold on. If it's not responsive, I'll strike it. But you can't stop him because I don't know what he's going to say. It might be something that's attached that is responsive, counsel. If it's not responsive, I'll strike it. Pardon me? He's describing, he said, counsel, he's describing something that was very active and he said crazy. He may not say it in the first word or the first sentence. Let him finish answering. If it's not responsive, I'll strike it.
Judge, my question was about a kick, not him to recite what he said already to Miss Rogers. Judge, you have to let me do my cross.
Counsel, you're the one that cut him off.
I cut him off.
He may not be done with his answer. No, you don't know what's responsive.
Judge, I'm sorry, this is impossible. I cannot effectively represent my client when the court's going to restrict me like this. I can't.
Counsel, I'm not restricting you. You're the one trying to stop the witness from testifying. If it's not responsive, I'll strike it.
Judge, let me rephrase
it if it's not responsive. You said it's not responsive. He wasn't done. I don't know if it's responsive. If it's not responsive, I'll strike it. It won't be a part of the record.
Mr. Kincaid, I'm going to rephrase the question and please listen to me. I've heard what you said already to Miss Rogers, okay? You've already said you may have touched my client with her foot. You've already said that. That's on the record, okay? My question is very specific, okay? When you may have touched my client with her foot, did the golden retriever bite you before that or after that? That's all I want to know. That's the question I asked you previously. It's a question I'm asking.
No, it wasn't that clear cut, counsel, because I didn't hear it in that way. So he can answer the question. Go ahead, sir. Answer the question.
Look, the answer is I don't know. All I know is
Thank you, sir. Now, if it was after, obviously the dogs were there, right? The dog bit you. Would you agree that you kick someone's owner, the dog's going to react, isn't he?
Objection, that's misstating
think-
the testimony.
yeah,
He never
I
said he
mean-
kicked the owner.
Hold
Oh,
on a
Mr.
second.
Kincaid, if
What-
you can.
Yeah,
Hold
sorry.
on, what, no, counsel, how can he say what a dog's owner is gonna do if he touched, kicked, or whatever? How do we know what that dog's response is gonna be? He can't talk, he can't say what's in the dog's mind. You can't even say if the dog saw it. You don't know. So that's not a valid question. The dog would have done something obviously because he kicked the owners. I don't know what he would have done.
After this incident, you walked your dog home. Is that accurate?
Yeah, I went home. I would not call it walking my dog home. I would call it limping. It was bad.
The dog was, I understand. I did see the pictures. I saw puncture wounds. I saw that, but the dog did walk home, correct?
Yes.
Okay. Again, you already testified to this, but you have no idea. You indicated you had no idea whether or not the dog was actually on a leash at the time of the accident, correct? Or the incident, correct?
Which dog
no.
are we referring to?
Either of the dogs, my client's dog, the pit bull or the golden retriever.
I saw her coming across the street with the two dogs. I saw two leashes and they were pulling her. She was coming across the street. And again, like I said, I thought she was going to pass by, but I could tell as they got closer that there were two leashes. They were pulling her across.
Okay, so you never once saw, again, my question is, you never once saw the dogs off a leash. You assumed that maybe they had gotten off, but you never saw that, correct?
Correct. Yeah.
Okay.
Wait, hang on. The other thing is I don't think I ever said anything about them being off leash. I think that's been brought up on leash, off leash, whatever. I'm just stating what I experienced there. That's, I don't.
Ms. Rogers, isn't that 5.2? Again, I can't read the citation. Doesn't that 5.2 have to do with leashes as well?
I can read it if you will allow me to
Sure.
read the written offense. Do you want me to do that on the record, counsel? I
Please,
can read my copy.
please.
It says fail to provide a lease and or a responsible person to hold on one second. That word is person. One word I can't read. It says dog off of owner's property.
I'm going to pull
Fail
up.
to provide a leash and or responsible person for the dog off owner's property.
Ms. Rogers, I guess obviously there's no other witnesses. Can we dismiss that one? I know we're in the middle of cross, but if the only witness can't testify that she had him on a leash, she had him on a leash, and he just stated that he never once said that they weren't on a leash, can we dismiss that so we can kind of get to the nuts and bolts?
If I could do redirect, please.
Oh, but then okay.
You're not done, are you yet,
No,
Attorney
I'm
Ryan
not
Hill?
done.
Okay.
Were you aware that my client's dog had puncture wounds and was bit by your dog? Were you aware of that?
No.
She never told you that in the conversations after this incident?
I don't think so.
Were you aware that her dogs were vaccinated at the time of the incident? Yes or no?
No.
Were you aware that she immediately went and got revaccinated after the incident? Yes or no?
No.
Okay.
Well, so to the point, brother, you're right. I didn't know that, but but as you've probably seen in the letters we provided, we asked for that information so that we could know we never received anything back on that, just as a note, okay?
I understand that, but you do understand
Yeah, I know.
why an individual would not respond when you're demanding that their dogs be euthanized as well, right?
No, we did not demand that they be euthanized. We outlined in our letter to her, we said, look, you need to be able to make sure those dogs are secured safely so this doesn't happen again. If that's not possible, then given what happened, yeah, we don't want anybody to get hurt. I don't think that.
If somebody was threatening to euthanize your dog, would you respond to them, sir?
Counsel, he has answered that question multiple times. He said he never demanded that they euthanize their dog. So he said that twice. Your questions on several occasions after that has said that he demanded that. He indicated he did not demand that the dogs be euthanized. So he answered that question. He said he did not do that.
You're muted, Mr. Hill.
My question is the court objecting or is Ms. Rogers objecting to my line of question?
No, I have indicated earlier, you asked a question and now you ask another question that says you demanded. He said just now, again, I never demanded that the dogs be euthanized, which you went into the next question. Well, if you such and such to counsel, he answered the question. He did not demand that the dogs be euthanized.
He admitted he demanded it. He had some.
No, he did not do that.
Can I finish,
He
Judge?
said,
Can I finish, please?
counsel,
Can I
I
finish,
listened
please?
to the evidence. He said he wrote a letter. He was asking about vaccinations, and he was saying that maybe that's something that should be happening. But he never demanded or asked that the dogs be euthanized. It was a follow-up to a question that he had put to them: was the dogs vaccinated, and some other questions. And he said there was some question about euthanasia, but he said he never demanded that that happen.
Let me ask you this way then, Mr. Kincaid, is that in your letter,
Yep.
do you suggest that if they were unable to keep their dogs under control, that you wanted the dogs to be euthanized?
Yeah, I mean, I'm looking at my document here.
Can you read it? Can you read it to the court, please? Thank you.
So we ask that you take we request these actions. You ensure your dog is not capable of doing this again. To be specific, given your dog's unprovoked, vicious, and devastating actions, we request you either euthanize the dog or place it somewhere. No. But I'm not demanding. I'm saying I don't even know why I'm defending myself here. All I'm saying is
Sir,
okay.
Just finish what you were saying.
Okay, thank you. So that you either euthanize the dog or place it somewhere where it can no longer hurt anyone permanently. We're not telling her to euthanize her dog. We're saying just make sure the dog can't be somewhere it can hurt someone. But if you can't do that, then
thank you, sir. So the very first thing.
Objection. Could he please answer his question?
Problem. Here's a problem, Ms. Rogers. Is that you listen? In every other court in the building, you're going to have an opportunity to cross-examine. Okay, right? He just read.
Counsel. She also has a right to stop. Hold on, counsel. You know, counsel. I'm just going to mute you.
Unbelievable.
It is unbelievable.
You're letting him explain a letter that I asked him to read the record.
Counsel, stop. I'm going to give you the opportunity to talk. The person was reading something and you have turned it around. He never said, hold on, counsel. Counsel, stop. He never said, I am demanding euthanasia. He said, I want you to take measures to protect the community. He said that. He said, if you cannot do that, this is an option. There was no demand. And then he never said he demanded anything. He read the letter to us, counsel.
He did. And the judge, you know what he did? He started to explain it. And I asked him to stop. And Ms. Rogers objected. And then you just supported her.
Because it was still part of his answer to you from you.
No, it's not.
The question that you put before him.
Oh my God. Judge, when I say read the letter, I didn't say read the letter and explain it. That's for Ms. Rogers to follow up, Judge. I said
counsel,
read the letter.
Counsel, he read the letter. He said, okay, move on. Move on, counsel. Ms. Rogers, were you done?
Yes, my objection was to allow the defendant or
say whatever he wants. To let him say whatever he wants.
To answer the questions that are presented to him.
Counsel. You may be upset, but you got to control your behavior.
Judge, I don't get it. I'm trying, Judge. But when I ask him, and maybe no one can hear me, maybe I'm muted. When I ask somebody to read the letter, I asked them to read the letter. He started to explain the letter. And I know the court has restricted me from certain questions. I get that. But I asked him to read the letter. I didn't ask him to give me his spin on it.
But you put your spin on it, counsel. You put your spin on it. That's the problem.
I'm just trying to ask questions, Judge.
You put your spin
I'm
on
getting
it.
objected
You turned
from
that
you
into a demand. He never said he demanded anything.
Judge, did you just listen to him read the letter? The very
Yes,
first
I
thing
did.
he says is you either euthanize the dogs or move them.
No, he said these are options. That was the one option. He said,
Okay, can you read
he
the
said,
two options
take
again, please?
measures to protect everyone. Or you can do this. He did not say, we are demanding that you kill your dogs. He never said that.
I would just ask the court and Ms. Rogers, if you could listen to my question that I'm asking before objecting, because my question was very specific. I asked him to read the letter. I didn't ask him to so I'm going to ask this, Mr. Kincaid.
I'm talking about what you said afterwards, sir. When he had read the letter, and then you turned, when he gave the options, you still turned that into a demand. You were talking to the court then.
I did not.
He said, when
That was a
someone's
previous question.
demanding, yes, sir, we have a transcript. So
I
will,
have a
Judge, I'm going to
question.
order it. I'm going to order the transcript. Mr. Kincaid, all I'm asking you to do is this. I don't need any commentary. And again, you know what? Ms. Rogers probably won't have to go and redirect after what's happened here today. But what I'm asking you to do is this. Read the two options again. The two options you gave verbatim. I have a copy here. Read it to the court, please.
Yep.
And stop after that.
You ensure your dog is not so this, sorry, I'm gonna get the front. I wish you all the best. I look forward to a day when we can both move beyond this incident. In the meantime, I am requesting 4 actions. 1, you ensure your dog is not capable of doing this again. To be specific, given your dog's unprovoked, vicious, and devastating actions, we request you either euthanize the dog or place it somewhere it can no longer hurt anyone.
May I stop you right there, sir, and ask that question? So the very first thing you say is either euthanize the dog or place it. You're meaning move the dog, not move it out of the neighborhood. Is that what you meant?
No, not necessarily. Just somewhere that can be secure.
Okay.
I mean,
okay. All right. But you do agree the very first thing that you ask for is either euthanization or place it somewhere else, right?
Yeah.
Okay. And again, to ask you a question, if someone asked you to euthanize your dog, would you have interactions with them after they asked you to put their dog down? Would you be a little hesitant to have a discussion with somebody after the very first thing they asked you to do was euthanize the animal?
I don't know. This is a pretty crazy incident. If our dog did all this stuff, I don't know what I'd be thinking. I'd be pretty scared, honestly.
Did you call the police that very day? Did you call them days after?
A few days after, yeah. We were.
It was after. That's fine. It was after you left these letters in my client's mailbox. You left 2, correct?
We did. We left 1 initially, and then we hadn't heard back at all, and so provided another one. And I think at one point we had also shared the emergency surgery bills too.
Can you look at the screen? Oh, hang on. Did you see that, Mr. Kincaid?
Yes.
All right. Are those the letters that you attached to my client's door?
No.
No?
No.
I'm sorry, if I could stop briefly. Whatever
I don't-
you're proposing as evidence, exhibits, I believe, I've never seen.
You've never seen these things before?
No,
No.
and they have not been. I'm sorry, Mr.
Oh, sorry,
Kincaid.
sorry.
Sorry, it's okay. The people have not been provided any of this. I
Okay.
don't believe so, at least. I can check.
No, you haven't.
I have or I haven't.
You haven't.
what are we looking at, Attorney Hill?
I just said no, well, nothing, because he can't identify it. So obviously I can't introduce it if he can't identify it.
Okay.
But you did state that you had sent 2 letters to my client. They didn't she didn't respond, so therefore you called the police. Is that accurate or no?
I don't know that the sequence was like that. My wife and I debated on this. I wanted the whole thing just to end, to go away. I didn't want anything else. I just wanted to get all the stress out of this thing and move on. And I remained, obviously concerned about the community overall, and we wanted to do the right thing to convey it to the police, and that's what we did. That's it.
Okay, it wasn't, you didn't call the police in retaliation because my client wouldn't communicate with you?
Objection, argumentative.
It's a question. It's a question, so it's allowed.
Thank you.
No?
No.
Have you ever had any instances with these dogs previously?
No.
Have you ever heard of any neighbors having problems with these animals?
No.
In fact, you've had other interactions with these dogs, correct? Like you've seen them out before and they've never been aggressive at all, have they?
I don't know that I've seen the dogs before.
I have nothing further. Thank you, Mr. Kincaid.
Judge, if I could proceed on redirect.
Yes.
Thank you. Very briefly, Mr. Kincaid, I know you've been testifying for a while now. Regarding if the dog was on the dogs at one point were on the leash, correct?
Correct.
And was when the dogs were biting both your dog, Chelsea, and yourself, was the defendant in control of the dogs?
No, in control of the dogs? No.
And could you tell if she was holding the leash at this point?
Objection asked and answered.
This is a fresh.
No,
No,
I don't, when was that question asked?
it was asked
I
on
don't-
direct and he said he didn't know. He said he didn't know if she was holding the leash. He said, I
Okay.
assumed the leash might have been released because the dogs were fighting, but he said he didn't know.
But she can go into some clarification based out after a cross, so we can do that just for clarification. So go ahead, counsel.
Thank you. Do you recall if she was holding the leash or not?
When it was going on, the attack?
Correct.
I really don't know. I just don't know how to express it to everybody on this call, but it was crazy. I'm on my back, it was just crazy.
I see.
Yeah.
Go ahead.
That's it.
The whole incident happened over probably the course of minutes, correct?
Yeah, it was. Yeah.
No, I understand. If you recall, was the defendant close to you, the defendant herself, close to you while her dogs were biting you?
I don't know. I recall kind of seeing her behind her dogs, because I think she was trying to stop them or pull them. She was, I don't know, behind them at some level, because I kind of came back and I'm on the ground and I'm trying to like fend off. I know the other dog was here and I could vaguely see her in the distance, over across the dogs, but she was behind them, I think, trying to pull them off, particularly the pit bull.
Okay. Could you tell if she was more than 6 feet away from you?
I don't know. It's probably around. I can't recall. I don't know.
Okay.
I mean, she was behind the dogs that are there. So I don't know what that distance would be.
Okay,
And-
thank you.
And can I say something?
If it's related to my question.
It is this whole thing about kicking or so forth. That this is, I don't know how else to say it to you guys. I'm on the ground trying to basically fend all this stuff off. I don't know where my feet are. I'm not, if somehow I touched her leg I don't know, like, all I know is, this is all going down and I'm trying to save our dog. I just should never.
No, thank you. I understand this. Sounds like it was a very traumatic few minutes.
Yeah.
And then regarding of when you called the police, and the investigator came, did you give a statement of what happened on that day to the investigator?
Yes, I believe, yes.
And was this
Yeah.
a truthful statement about what happened on the day in question?
Yes.
In post sending your 2 letters to the defendant, did you ever send any additional letters to the defendant?
No, we kind of just stopped. I didn't, we were felt like we were stuck in it. I didn't want to relive it anymore. It was just, I mean, that's why this whole case, all this stuff even now is kind of gut wrenching. We so desperately as a family, we've got 3 little kids. We just wanted to move on. And I don't even know if that was the right thing, but we just wanted to move on. So this is all just rough.
I understand. Thank you. Nothing further from the people.
Nothing based on that, Judge.
Well, Mr. Kincaid, you could go back into the breakout room, or we can put you back in, or well, hold on one second. Attorneys, can we release Kincaid?
Sure. I mean, I don't,
Yes, he can be released.
All right, Mr. Kincaid, you're free to sign off.
And Mr. Kincaid, I'll give you a call on the phone later today.
Okay, thank you.
Thank you very much for appearing today.
Thank you.
Sydney, before I call my witnesses, the very last ticket, the 5-2 is, you said section 622B?
Correct.
Okay, counsel, if I can assist on that, I do have 622B.
So I'm looking at control of dogs, section 621, 622. There's no B.
Where I just looked at it.
It says dog license requirements. This code shall not apply to any dog temporarily within the city. 622 6-2-2 is dogs within city limits for less than 30 days.
Wait, I'm confused. Are you looking at 622B?
I'm looking at 622. Section 622 doesn't have a B.
I'm looking at it. On Muni Code, I see section 22B. No owner of dog shall allow dog to be off property. Wait, do I have that?
6-2-2.
Correct. I'm on just
I-
Muni Code online.
I am too, and it says 622 is dogs within city limits for less than 30 days.
Ms. Rogers, could you email that to, or I don't know, are you looking on a computer, which you can't show us? Can you screen share it with Mr.?
Oh yeah, I
Orion?
can email it, but screen share is probably the easiest
Yeah.
to see what the problem is.
Unless that I'm on an old Muni code.
I'll show you what I have.
Doing the same thing mild though, okay?
Okay, can you see my screen?
Yeah, that's not what I have. Dog restraint, prolonged tether, prohibited.
This is, I just got a Muni Code a few minutes ago.
Sure, okay, and you guys, that section 5-2, you're going on. No owner of a dog shall allow a dog to stray on a public street or unless held by a leash, which is extended more than 6 feet. Okay, all right, thank you. Judge, I guess I would have a motion for directed verdict on the 5-3 ticket, the 622 dog restraint. I think there was no testimony. Actually, the testimony was that the dogs were on a leash. He was unsure whether or not the actual dogs were off a leash.
Counsel, one second. The 5-3, I thought Ms. Rogers had not objected to your motion to dismiss.
No, she did object and she wanted to put proofs on, unless you're going to stipulate now, Sydney.
That was the
This is-
ticket where it doesn't look like the officer signed the ticket.
So first, I think this motion is premature as the people have not rested. I still have another witness.
Oh, you do?
Investigator Green.
But if he wasn't there, can't we just take care of this now?
Well, I need him for, I have an issue with a date. I need him for the document cases.
Okay, but let's just, okay, I'm not gonna tell you your case, but just the facts of the leash thing, can't we address that ticket without him or no? And there's a reason why I'm asking that. Because what's left?
That'll be the document cases.
Then I'm not worried about those. What I'm saying is if you're gonna stipulate to that, then you know that everything was corrected, then we don't have to go to trial on those. That's what I'm telling you.
You can handle your motion first, but I can't stipulate to it.
Okay, so I'd have a motion, Judge, to dismiss, being on the fact that directed verdict. The only witness to the incident could not establish that the dogs were off a leash. He assumed because there was an attack going on. And I don't think that they've established their burden, so I'd ask the court to dismiss.
All right, Ms. Rogers?
Yep, thank you. Looking at this ticket, looking at the Muni code and what the victim witness testified to, that this incident happened over just a few minutes. It was a very quick incident. Clearly the defendant was not in control of her dogs. If the defendant had the dogs on the leash the entire time and allowed the dogs to bite a person and another dog, that would be a whole different charge here. This happened very quickly. The defendant or the victim witness said that he couldn't see everything, that the dogs were once on the leash, but when they were attacking him, he thought that they were not on the leash and that the defendant herself was behind the dogs. He wasn't sure how far away they were. She could have been more than 6 feet away from him, but the defendant was not in control of these dogs while they were attacking the victim witness, or that would have been charged differently if she was controlling them and telling them to attack. It doesn't appear that they're on the leash here. It's hard to for the victim to remember everything that happened here and the details of everything because this was such a traumatic event and happened so quickly. But the dogs were not being controlled by the defendant.
Can you go
clear.
back to the Muni code so I can see the language of that?
Correct. Yes.
Okay, I'm reading it. I'm just gonna do it out loud. So no owner of a dog shall allow the dog to stray on public or private property other than the private property of the owner. That does not apply unless held properly by a leash, which is extended no more than 6 feet or under restraint, provided that police dogs accompanied by their trainer while inactive, those dogs are trained and not subject to. All right, Ms. Rogers, let's see. Counsel, I'm having a difficult time finding how this is applicable in this case. If we break it into parts, no owner of a dog shall allow the dog to stray. Okay, that obviously didn't happen. Other than the private property of the owner unless held properly by a leash, which that doesn't apply, or which is extended no more than 6 feet or length or under restraint provided that police dog. I don't see how this language applies in this matter. You were speaking of, and I know there is something out there somewhere that talks about even that the dog must be maintained or his conduct or activity must be controlled. I don't see where I have that in this statute or in this section under the Muni Code. I don't see anything that says the dog did have a leash or a tether, but it does not, in this section, it does not talk about maintaining some type of control. I believe that is something out there in one of these sections, but I don't believe the section that it was charged under is applicable.
Okay, thank you, Judge.
So Sydney, what does that leave us with? 2?
That's correct.
Can we plead to 1 under delayed now that she's in compliance with everything?
I can make it contingent on restitution.
As long as we have a hearing on restitution, I'm not going to agree to whatever numbers provided. We'll let the court decide, right?
Correct.
Actually, if there's already receipts for restitution and they appear to be as a direct result of this, I think that's something you might be able to agree on. So
Well, how much is
they're
that?
not making up numbers if they have from either the doctor's office or whomever did anything, and there's provable things and not just, well, I think I should get more money for something.
Judge, we can, Sydney, you and I will work that out, right? Like, the only reason why I say that is I had a case in Judge Bryant's where the guy was asking for 6 weeks of lost wages. We had to hold a hearing. So if you can do a 1-for-1 on a delayed, my client will pay. We'll agree to pay restitution. If there's an issue, then we agree that the judge can do a quick hearing. Is that okay?
There will be one guilty plea with a 12-month delayed sentence.
12 months.
That's the best I can do.
Sydney, listen, the 2 charges were dismissed. We're talking about a vaccination now, and we're talking about an unlicensed dog. We're not talking about unleashed and no control. Those were dismissed.
That's best I can do.
Can we go off the YouTube?
Yes, we can do that. This is just some, yeah. Let me do that. Crystal, could you turn the YouTube off? Because
Is it what?
they want to